Thank you very much, Chair, and thank you to those for attending today. I first of all want to state my clear commitment to the right to housing. I'm really appreciative that it's in the programme for government. I'm a little bit disappointed that we've had arguments which were perhaps being rehearsed here that were being made by the previous government about why this wouldn't happen. This is a government commitment, and I believe all parties to government should be committed to championing it. And I hope that we can continue to do that in this committee. I suppose my fear is that this will pass, but will make no practical difference. So let's make sure that when it passes, it has teeth. I look back at the Mercy Law and the Trinity FLAC document in 2014, which is a really good synopsis for any members who wants to read about the international examples. And one of the biggest issues there seems to be the area of judicial activism. And there is the fear that even if this passed and a case was brought to court and the state pointed to HAP, homeless hubs, emergency accommodation, that actually it would pass and there would be no additional obligation. And I think that would be a really big missed opportunity. And given the state's failure to interpret the words public good or social justice in the Constitution in an ambitious way, I would be sceptical that they would do any different on this one. So I think that's something we really need to think about. In the environmental area, we've talked about moving away from individual change to systems change. And I think, again, this wording leads too heavily on the individual change and not on the system change. Local authority members here will tell you that the real reason why we had lots of difficulties were the private property rights. The real difficulty we can't have a complete ban on evictions or rent increases is because of property rights. And I'm right in saying that none of the wording here would necessarily allow government to do that. So what we would do is we would put the obligation on government to provide housing, but not give it the tools to balance the private property rights. So what I would like to see, and I'm very concerned about the phrase within its resources. I'm not sure. I would like to remove that. Right? And I'd like to see how we could tease that out. But for example, why did you not give consideration, for example, to defining the common good in the context of a right to housing? So actually moving it to that place. Because honestly, even if we have a balancing and then we have to pay full market developed value to developers or property owners, that doesn't then provide any affordability or doesn't allow our ability to deliver housing, that doesn't actually achieve what we want here either. So I think we're leaning too strongly towards individual change here, and I would think we should focus a little bit more on that interpretation of the common good in the context of providing housing. But I really appreciate the work that you've come forward.
Thank you very much. You've really hit on something that we did discuss in some great detail in relation to if we were to propose wording that tinkered with Article 43 itself, and whether there was scope to greater define the common good. This was considered through the Home for Good group and the legal subgroup, and ultimately that is why we've come to the conclusion that a standalone right will actually provide much greater protection and will have greater force and impact. And that's because then you have two standalone rights that are competing against each other. You don't have that internal tweaking and balance that happens, which has been that block that has been so identified and discussed today. So, I mean,
that right is assigned to the citizen, but not to the government. And actually, what we need to do is empower the Oireachtas with the right to intervene.
I mean, I hear you on that, but I suppose that's what the second limb is designed to do. The state shall, through legislative and other measures. And, you know, in other fora, you know, you can look at the Finnish example. There's similar phrasing, but it does lead to legislation being examined in a broader way, not just looking at the individual rights. So, for example, in our report on Finland, this constitutional committee that Rosemary mentioned looked at legislation that was going to give subsidies to entities providing social housing and looking at whether they could sell those properties, and ultimately said that that wasn't going to be consistent with their constitutional protection to the right to housing because it was going to take it out of the stock. So I suppose that's looking at a more broader systemic impact that it could have, and I think Jerry will speak to the kind of broader constitutional architecture, but I think it is fitting within the architecture that it is phrased as all persons, and you know, all policies and legislative measures will have impact on persons. I might just speak to your query about judicial activism. I mean, we work, you know, at Mercy Law, we're working really very much at the sharp end of the housing crisis, and working with homeless families, many of whom are your constituents who you're meeting. And you know, the 88 Act is a discretionary discretionary provision. And at the moment, we are relying on rights around the edges. We're relying on fair procedures, we're relying on right to family life, but this measure would enable us to say to local authorities, you need to act in a manner that is compatible with the Constitution, and the Constitution protects the access to adequate housing. So it would recast how that assessment would be done. Jerry has highlighted this. We don't see matters coming before the courts. This isn't designed to create legal cases. This is, it'll only be an egregious and very serious infringements that those cases would get to the courts. So just to give you that example, just from our own practice.
But I don't see the Attorney General giving us different advice, for example, on an eviction ban, on a rent ban, on a more ambitious Part 5, based on this amendment. Yeah.
I'll defer. Well, we've discussed this. I'll defer to Jerry on that because it's something that we've been discussing.
Yeah. If I could just come in on that point. In fact, I would think that the amendment would enhance the ability of the Oireachtas to legislate in these areas. And it goes back to the point we've made earlier, that where you have two competing constitutional rights and where the Oireachtas attempts to balance those competing constitutional rights, the courts will only upset that legislative balance if the balance is completely contrary to reason and fairness, or rationality and fairness. Currently with regard to property rights, what you have is a guarantee of private property qualified by this concept of the common good. That is a different situation, and we don't really have enough detail about what the common good requires in this specific situation to predict confidently that legislation restricting private property rights would pass. But in a scenario where you're told, look, legislation will be sustained by the courts unless it is unreasonable and contrary to common sense, that gives a lot of room for the Oireachtas to legislate around things like security of tenure, rent freezes and the like. So I do think from a technical point of view, inserting this specific right to access to adequate housing in the Constitution would address that issue around the perceived limits on the ability of the Oireachtas to legislate in this area.